Section 1. The closing that suddenly wasn't closing. Friday was supposed to be closing day. Imagine you're representing Emily and Carlos Ramirez, first-time homebuyers purchasing a home in Gilbert. It has been a long transaction, but everything finally seems to be coming together. The inspection is finished. Repairs have been negotiated. The appraisal has been completed. Escrow has the documents it requested. Emily and Carlos have already started packing, and the sellers are preparing to move out. Closing is scheduled for Friday. Wednesday afternoon, Emily calls her agent, Sarah. Sarah, we just received another document from the lender. Carlos says some of the numbers look different. Are we still closing Friday? Sarah opens her email and sees the document Emily is talking about. It's a closing disclosure. Sarah's first instinct might be to reassure her client. Don't worry, everything is fine. You'll definitely close Friday. Stop right there. Here's where a well-meaning real estate agent can create a problem. Sarah doesn't control the lender. She doesn't control underwriting. She doesn't determine whether federal mortgage disclosure requirements have been satisfied. And she certainly shouldn't guarantee a closing date before finding out what changed. Welcome to TRID. What exactly is TRID? TRID stands for the TILA-RESPA Integrated Disclosure Rule. Those letters come from two major federal consumer protection laws, the Truth in Lending Act, commonly called TILA, and the Real Estate Settlement Procedures Act, commonly called RESPA. For years, consumers purchasing homes with financing received multiple federal disclosure forms containing important information about loan terms and settlement costs. Federal reforms ultimately led to an integrated disclosure system intended to make important mortgage information easier for consumers to review and compare. For this course, two documents are going to become very familiar: the loan estimate and the closing disclosure. Think of them as two important checkpoints in the mortgage process. The loan estimate generally comes near the beginning and provides important information concerning the proposed loan and estimated costs. The closing disclosure comes near the end and provides the consumer with important final information about the mortgage and transaction before consummation. We're going to spend plenty of time with both. But TRID is about much more than recognizing two forms. Why does the law exist? Imagine buying a home and not clearly understanding the interest rate, monthly payment, closing costs, or other significant loan terms until you're sitting at the closing table. That's exactly the type of consumer problem federal disclosure laws are designed to address. Consumers should receive meaningful information early enough to evaluate a mortgage transaction, and should receive important final information before becoming obligated on the loan. That's why timing matters. That's why accuracy matters. And that's why changes late in the transaction can sometimes become a major issue. But I'm a realtor, not a lender. That's true. Sarah isn't responsible for underwriting Emily and Carlos's mortgage. She doesn't calculate their annual percentage rate. She doesn't determine whether the lender may revise a particular estimate. She isn't responsible for preparing the lender's federal disclosures. So, why should Sarah understand TRID? Because she's managing a real estate transaction affected by TRID. Let's look at an example. Suppose Sarah tells the listing agent, everything is cleared. We're absolutely closing Friday. The sellers schedule movers. They scheduled a purchase of their next property based on Friday's closing. Emily and Carlos give notice to their landlord. Then Thursday morning, the lender identifies a disclosure issue that affects the anticipated consummation date. Suddenly, everybody wants to know why Sarah promised Friday. This may seem like a small communication issue, but it can become a major transaction problem. The Arizona agent's role. Arizona licensees have duties to their clients under AAC R428-1101, including protecting and promoting the client's interests while dealing fairly with all parties to the transaction. That doesn't mean Sarah has to become a mortgage compliance attorney. It means she should know enough to recognize when something needs attention. When Emily says, my closing disclosure changed, Sarah should start asking appropriate transaction questions. What changed? When did Emily receive the disclosure? Has she spoken with the lender? Has the lender confirmed whether the anticipated closing date remains achievable? Does escrow know about the issue? Does Sarah's broker need to be involved? Those are very different questions from Sarah telling Emily, I've reviewed the federal regulations and your lender definitely complied. Know the difference. Recognize, communicate, document, refer. Here's a simple approach I want you to remember throughout this class. Recognize, communicate, document, refer. Recognize when a lending or disclosure issue could affect the transaction. Communicate with the appropriate parties. Document important conversations and developments in the transaction file. Refer technical lending, legal, tax, title, or settlement questions to the appropriate professional. Experienced brokers don't expect their agents to know everything. They expect their agents to recognize when they don't know something and get the right professional involved before the situation becomes worse. Broker tip: never promise what you don't control. Be careful with statements like, you're definitely closing Friday. Instead, communicate what has actually been confirmed. The lender currently anticipates Friday, but I'm going to confirm that there are no remaining financing or disclosure issues affecting closing. That small difference matters. Sarah now knows she shouldn't guess about Emily and Carlos's closing disclosure. But to understand how they reached this point, we need to go back to the beginning of their loan. Because before there was a closing disclosure, there was another important TRID document, the loan estimate. And that's where we're headed next. Online discussion 1. Emily asked Sarah, "Can you review my closing disclosure and tell me whether the lender calculated everything correctly?" What should Sarah do? Answer. Sarah can help Emily understand where she is in the transaction and assist with communication, but she should not assume responsibility for determining whether the lender's calculations comply with federal lending requirements. Questions involving loan calculations, APR, lender fees, or federal disclosure compliance should be directed to the lender or another appropriate professional. Sarah should remain involved because the answer may affect contractual deadlines or closing. 2. Why should an Arizona real estate licensee understand TRID if the lender is responsible for the mortgage disclosures? Answer. TRID requirements can directly affect the timing and progression of a financed real estate transaction. A licensee who understands the basic process is better prepared to recognize possible delays, communicate accurately with clients and other professionals, manage expectations, document developments, and involve the broker when an issue could affect contractual performance. What is the danger of Sarah telling the listing agent that the transaction will definitely close Friday? Answer. Sarah does not control all of the requirements necessary for closing. Financing, underwriting, disclosure requirements, title, escrow, and other issues may still affect the transaction. Making an unconditional promise can create unrealistic expectations and unnecessary disputes. Sarah should communicate only what has actually been confirmed and continue monitoring outstanding requirements.